everything.
Oh, that's right. That's right. You house cat, you.
It's Friday. It's Friday, and it's been a busy, busy week here at Law and Legitimacy. And in my life, yesterday,
What up, Norm?
Yesterday, when I drove home from the appellate court after argument in Lafferty v. Jones, the Sandy Hook case, I felt a huge weight lifted. And I realized that it's been almost precisely 5 years since I first got involved in the Alex Jones Sandy Hook case. And what a 5 years it's been. So we gave the arguments yesterday in our efforts to vacate or overturn the $1.5 billion judgment against him. The appellate court didn't seem very interested in our request that they create a bright line rule saying civil default is never appropriate in the face of partial compliance with discovery. However, they were intrigued by our arguments that the damages were absurd and were too high and offended a sense of justice. So let's see what happens. But I can tell you that I feel the weight of a huge weight off of my mind. I mean, there'll be one last set of briefs. The loser in the appellate court will undoubtedly ask the Connecticut Supreme Court to weigh in, and the Connecticut Supreme Court may or may not choose to hear the issues. My suspicion of the Sandy Hook case in Connecticut is there's not a judge that wants to get involved. It's a hot potato, and I think they're going to find a way to stick it to Alex if they can do so with a straight face. Anyhow, lots of other stuff in the news yesterday. Mike's got a great headline here. Did Hawaii just succeed? You know, if you're listening to... yeah, it's a great question. I mean, I can't recall the name of the case, but the Hawaii Supreme Court, the first paragraph of a recent decision, I think a decision yesterday, in a right to bear arms or carry firearms openly in Hawaii, is shocking. The Hawaii Supreme Court says, hey, while our right to bear arms resembles the Second Amendment to the United States Constitution, go ahead, scroll down. We just disagree. Here we go. Article 1, Section 17 of the Hawaii Constitution mirrors the Second Amendment to the United States Constitution. We read these words differently than the current United States Supreme Court. We hold that in Hawaii, there is no state constitutional right to carry a firearm in public. And you're thinking, okay, there's the 10th Justice, Donnie Ho. He comes in with his lei and doing a little bit of, hi, aloha, everyone. I mean, this, but I want to unpack what this ruling means and what it doesn't mean.
God, some abounds in a country that is surrounded by ocean and world superpowers. You idiot.
Hey, Katanji, pass me the coconut, will you? I need some coconut milk. Oh, no, I can't tell whether it's a coconut. I mean, I don't. No, we're not talking about gender, Katanji. We're talking about things that bear milk. Yeah, but women's breasts might bear milk and men's breasts might too. I just can't tell. But anyhow, look, federalism, the division of powers. This is a classic federalism decision, and law nerds take note. What's the name of the case? The caption of the case, Mike? Hawaii versus
State v. Wilson.
State v. Wilson, a Hawaii Supreme Court case. It illustrates what we talk about in terms of basics of the law. So remember, again, the fact of government is the mystery that requires explanation. A constitution sets its outer limits, and it talks about how the various pieces of government hang together and the rights of responsibilities of government towards citizens and rights of citizens as against the government. A federal constitution governs a large territory. State, in this case, the United States. State constitutions govern smaller territories, in this case, Hawaii. And the differences between the two can be significant. The federal constitution sets a limit on what all jurisdictions within the United States can do. So, for example, in a Fourth Amendment context, the federal Constitution's protection against unreasonable searches and seizures goes so far. No state can go below what the federal constitution guarantees, but they can offer protections in excess of what the federal government does in their states. So, for example, trash pulls or a homeless person's garbage is not protected under the federal constitution from searches and seizures. It is protected in some states, as in some instances, Connecticut. And so state court criminal practitioners need to study their state constitutions and the case law arising therefrom to see whether there are rights in excess of what the federal government offers. And then you can challenge in a state court whether your client's state constitutional right was abridged by a various state act. Though this case is the flip side of that. The Second Amendment under the federal law recognizes an individual right to bear arms. No state is free to say we're opting out of that. And Hawaii appears to have done that. But basically, what it's done is asked Mr. Wilson to take a trip to the United States Supreme Court, because here are the facts. Wilson apparently didn't register or ask for a license to carry a firearm.
If you don't mind, I'll give the quick background.
Yeah.
So, yeah. His name is Christopher Wilson. He was arrested in December of 2017 for carrying in public a .22 caliber pistol, and he was carrying it in his front waistband. He claims that he was actually carrying it while he was hiking for self-protection. Hawaii has a statute that requires that all firearms be confined to the possessor's place of business, residence, or sojourn. And the only exceptions for actually transporting those firearms in closed containers, for hunting or target shooting, and for those with a license. So Wilson argued in defense of his prosecution that, he was that prosecuting him for having a firearm for the explicit purpose of self-defense outside of his home was actually a direct violation of the Second Amendment. He lost at the trial court level, but pending all of that, the Supreme Court issued its decision in Bruin. And then the circuit court judge in his case dismissed the charges with prejudice thereafter. This decision comes directly after that, and apparently is sort of a mockery, I guess, of the holding in Bruin, and talks about the spirit of aloha being in conflict with the federally mandated lifestyle that lets citizens walk around with deadly weapons during day-to-day activities.
Well, yes and no. So here's where I think the case gets complicated. The while we may have an individual right to bear arms under the Second Amendment, the states still retain the right to require registration, for example. And so Wilson's claim that somehow he's not required to apply for a license, I think is wrong. And I think will give the Hawaii Supreme Court some traction. But I think that when Wilson takes a petition, and the authors of the Hawaii opinion say the record before it is pretty slim to none. And so I believe that the United States Supreme Court might take a pass on a writ of certiorari for this case, claiming that the facts below, that there's not an adequate factual record below. And that because this record suggests that Wilson refused to register, and states can register, they just can't forbid. States can require registration; they just can't forbid a person from registering, for example.
Well, and recall, Norm, in the Supreme Court case in Bruin, that was a licensing scheme in New York that had actually heightened this special standard for those seeking a permit, and that was what was actually rejected, was this notion that the state of New York had a basic license application process, but then were requiring the average citizen to have some sort of specified emergent or urgent need to carry.
Bruin didn't hold that you couldn't require registration at all, and
Correct.
That's the pigeonhole that Wilson is in here. I think the Supreme Court might be tempted to take certiorari just to slap at Hawaii, however, and say, we're not really interested in your advisory opinion. You may respectfully disagree with our holding as to the Second Amendment, but we remind you that we are the supreme law of the land. Or in the because I don't. But I think that going forward, Wilson gets successfully prosecuted by Hawaii, notwithstanding this asinine ruling by the Hawaii State Court, because he failed to register at all. And so the issue lurking in this case, the sleeper issue, is that issue. And why Hawaii chose to write this decision in such a flagrant and inflammatory and in your face and F you and the train you rode in, Justice Roberts and the Supremes. Why it chose to do that, I'll never understand. That seems to be a little inconsistent with the aloha spirit.
Yeah,
You
well,
know?
here's I'm gonna read an excerpt. It says, Bruin's command to find an old days analog undercuts the other branch's responsibility at the federal, state, and local levels to preserve public order and solve today's problems. And it downplays human beings' aptitude for technological advancement. Time traveling to 1791 or 1868 to collar how a state regulates lethal weapons per the Constitution's democratic design is a dangerous way to look at the federal Constitution. The Constitution is not a suicide pact. We believe it is a misplaced view to think that today's public safety laws must look like laws passed long ago. Smoothbore, muzzle-loaded, and powder and ramrod muskets were not exactly useful to colonial-era mass murderers. And life is a bit different now, in a nation with a lot more people stretching to islands in the Pacific Ocean. As the world turns, it makes no sense for contemporary society to pledge allegiance to the founding era's culture, realities, laws, and understanding of the Constitution. Quote, the thing about the old days, the old days, which is a direct reference from The Wire. I don't know if you've ever heard of that HBO series,
Yeah.
The Wire.
Oh, I've
So
watched it, in fact.
it's a great show. Not necessarily fit for, I guess, reciting in a Supreme Court opinion for a given state. But I found that, that sort of mockery is what I was talking about. So while I agree within the cloud over on Rumble that, a 22 while you're hiking might as well have had a slingshot, I do agree with that. How feckless of a firearm to be carrying for self-defense purposes. I also understand that this case is not even necessarily about the regulatory scheme that the
No.
state, you know what I mean? This opinion
No, this is about constitutional interpretation. If you want to see an example of those who believe the living Constitution is the way in which we should interpret this, that justices should be free in an untethered way to address the exigencies of their situation according to contemporary norms, standards, and however they see fit. This is the perfect example of it. It basically said to the originalists, oh, give me a break. Get in your horse and buggy and go do your Civil War and colonial reenactment on your own time. We live in our time, and our time demands an exigency which we are best fit to address. So, constitutional scholars and constitutional scholars in the making, this is the living Constitution at work. Does it work for you? We'll see.
Mari asked a question, and I think that, Norm, I definitely want us to focus in future streams on more Second Amendment analysis and developing some home for that here. I think that it's an important item, especially considering how much of the First Amendment we engage with. But to me, in my personal view, those two things go hand in hand. We don't have the first without the second, right? And the second secures the first. Ultimately, I'm looking at this comment from Mario, this question. Amari asks, what right does the government have to even know if you have a gun? Isn't that a privacy issue? And the interesting thing here is that we just had a Supreme Court opinion which puts the idea or the notion of some sort of inherent right to privacy in jeopardy. No?
Well, there is no constitutional right to privacy. I mean, that's, if you look at at least in my view, if you look at and it's one of the faults of the Constitution. The federal government is a government of limited powers, or at least it was initially. And it gave to the federal government rights to do some things, but not others. There was a Bill of Rights that was proposed immediately after it was adopted because anti-federalists assumed and thought that too much power was given to the government. And they wanted to secure certain rights as against the government and make sure that the government knew it couldn't abridge those. Opponents of the Bill of Rights and some proponents worried that by offering a Bill of Rights, it would say to the government, oh, we can't do this. We can do everything else. And that's inconsistent with the spirit of a government of limited powers.
I thought you were about to say aloha.
Yeah, state governments have a residual police power to govern in the name of the health, education, welfare, and safety of their people. But and state constitutions can guarantee a right to privacy, but there really is not one in the federal constitution. Attempts to find one have largely parked it in this notion of substantive due process, and substantive due process, or a sense of fundamental rights, basically says these are those rights that are so fundamental we can't imagine an ordered society without them. And so, Maury, I think the answer to your question from some, I'm not saying from me, but in the universe of constitutional scholars, would be that there is no right to privacy, but we have certain communal expectations. And one is the ability to move about freely in our communities. And because firearms or weapons in general pose a threat to that, the government maintains a right to regulate them and regulate their possession. I don't know that I agree with that. I think there probably ought to be a federal right to privacy. And I actually think that this is one of the areas in which we're coming apart at the seams as a country, because we had a certain consensus about values in the United States, which served as the background against which the Constitution was enacted. Those have evaporated, and now we have a sense of personal agency untethered to any broader notions of human destiny, excellence, righteousness, and so forth. And identity trumps everything, and therefore we're all equal in how we express ourselves. And there goes the herd off the cliff. So, Maury, no, finding a right to privacy in the United States Constitution is a lifetime's work. It maybe could be amended to that end. Those, for example, who favor a right to abortion could take that as a rallying cry and seek to amend the Constitution to contain such a
Yeah,
right,
you
and
know what?
park abortion within that.
We should encourage abortion advocates to take on the hard task of lobbying Congress to pass a federal right to privacy, just so that we can have them do the dirty work of ferreting out the intelligence apparatus as it exists, and also expose just how foolish a notion of privacy in the modern era actually is. I think that what we're narrowing to here, Norm, is maybe we're just entitled to the illusion of privacy.
Yeah, I don't know. I mean, folks, if you're looking for answers on this podcast, you're often going to be frustrated. All we can do is raise the questions, because these are conundrums. There are a number of possible answers that cohere and that may be right. I don't have an answer for this one. So, yesterday's arguments in the Supreme Court. It appears that it's going to be 7-2, 8-1 in favor of keeping Trump on the ballot. What I've read of the arguments, and unfortunately, because I was in court elsewhere, I was unable to listen to the live stream of the arguments themselves. But what I've heard suggests that the court was dubious on slippery slope grounds about making Section 3 of the 14th Amendment self-executing, on grounds that the language was insufficiently precise, so that it would not, so that if we permit this to be self-effectuating, we'll be disqualifying one another's candidates at will and depriving the people of the right to vote. I think that's probably right. Sonia Sotomayor, I don't know. I don't know what planet she's on. I once had dinner with Sonia Sotomayor. She was a very active panelist on the Second Circuit when she was on the appellate court there, and I appeared regularly before her, and we often got into it. And I loved those arguments. She was famous for bringing a hypothetical that she thought would defeat your case. And I would always respond by saying, well, if that hypothetical is so, how do you respond to thus? And she'd say, counsel, I'm not here to answer your questions. So this happened twice in a row in 2 consecutive months. And without thinking, I said from the well of the Second Circuit, Judge Sotomayor, this is the second time in as many months that we've had this impasse. When are you going to invite me to dinner so that we can discuss our philosophic differences? Lo and behold, she did. And, dinner with Sonia was a famous event for me. I mean, she suggested at that point that I become a federal judge. I told her no one in their right mind would appoint me, and I've never put that to the acid test. But she is out there on a one-woman mission to do something, and I'm not sure what it is.
She did the same
Hmm?
thing with the COVID stuff, Norm, where it's just
Hmm.
sort of she appears to be so susceptible to um, a particular part of the entertainment discourse, right? Whatever establishment media in a very like not even a slim pocket, but in a very particular pocket is pushing. In particular with COVID, if you recall, she was citing figures of dead children that were completely erroneous in Supreme Court opinions or
Yeah, and that's problematic.
oral arguments, right? So I have a serious question as to her diet of information and also her ability to um, hire her offices, right? Who is staffing? Who is she relying on for
Well,
legal
and
research?
let's put this in the perspective of constitutional theory and theories of constitutional interpretation. Courts frequently say that the Supreme Court frequently says of the courts that it is not a good fact finding body. The Supreme Court brings to it the information that others brief, but it doesn't engage in independent fact finding with evidentiary hearings and the taking of evidence to determine what is and isn't reliable. And Sonia's use of miscellaneous statistics and data that her clerks find her to prove her point sort of illustrates the dangers of a judiciary untethered to larger doctrinal commitments. You're not there to do justice, Justice Sotomayor. You're there to decide cases according to law. And if you have a particular and passionately held view of how to make a better world, then get off the court and go run for office. Sonia is busily sawing away at the board she's standing on. And one of these days it's going to break and she's going to fall into the pool and drown in her own rhetoric. But in any case, I expect a prompt decision, Mike, would you say within 30 days to clear the field,
Yeah.
and then off we'll go.
Interesting is I think it was, I can't remember the attorney's name, constitutional law attorney. I think I sent you a thread yesterday on Twitter.
Was it Chemerinsky?
No, and no, he's gone off the deep end too, it appears. He's an actual lawyer. And I'm sorry, Chemerinsky. I read a lot of your books in law school. But maybe you're not the same Chemerinsky. Who am I? But it was, and I'll find that thread and maybe try to retweet it. And maybe I did retweet it on LawPod Daily on X. But it was an assumption or a bet that the issue would come down to an 8-1 or even a 9-0 vote.
Mm-hmm.
Based on, and this was obviously before the oral arguments, probably a day before. So that prediction may end up being pretty correct based on the reporting and any of the reading from the transcripts from yesterday's oral arguments, given the types of questions that the justices were asking, with save for that of Sotomayor. But if we get a 7-2 decision, I don't think that I would be necessarily surprised. What I don't want is a 5-4 opinion in favor.
Yeah, well, I don't think we're going to get that, but let's see what happens. I mean, it's Trump, Biden, and let's turn to Biden. I mean, I'm beginning to think that there's a great setup to get Biden elected and then claim that he's incapable of serving under the 25th Amendment. Yesterday, Special Prosecutor Robert Hur released his report declining to prosecute Biden for misuse of classified documents. And in it, he recited a complex series of factors in the Justice Department manual about whether to prosecute. He made some comments along the way that suggests that Biden really is incapable of the office he holds, doubting that a jury would convict an elderly man with a poor memory. What's odd about this, and Michael Reed, maybe from some of the document we were talking about it this morning, is that language could almost equally be applicable to Donald Trump, although no one's claiming he's got as poor a memory as Joe Biden. But so the claim is that Biden took classified documents that were nationally that were supposed to be kept secret in the national interest. He took them from his office. He shared them with a ghostwriter who was writing a book to justify some of his decisions with respect to Afghanistan, and he did so knowing full well that those documents were classified. In other words, he shared national security information with a ghostwriter to serve his private interest in bolstering his image in history. I mean, how is that not a willful misuse of classified documents? The prosecutor then goes on to recite a number of factors that suggest that while this is bad, while this is bad, there are mitigating factors. But here's the thing that's shocking. He acknowledges that one of the answers that Biden gave to questions about this were incredible. But he won't go so far as to say that the non-credible answer Biden gave was a lie. And he does it in part because Biden was ultimately forthcoming, and he's got a poor memory, and he's an elderly old guy, and we don't typically prosecute 80-year-olds without criminal records. Huh?
I'm trying to pull up some of this language, but the document is so large that it's a 388-page report for those wondering. And I'm going to refresh this tab so I can actually share it and just at least show you. This is on the Justice Department's website. You can see here that Special Counsel Hur has provided this to Attorney General Garland. And you're right, Norm. I mean, there are two major conclusions of this probe. So a 388-page document is just insane. And so
You know what we'll be doing this weekend here at Law and Legitimacy, folks?
Well, I don't know if
At least what one of us will be doing.
Yeah,
Mike,
yeah.
let me know how it goes after you've read it. Tell your wife and children to have a nice weekend and that you'll be in the study,
So we could put here just the sort of table of contents so our viewers can, and I'll read a few here for our audio only, but the overarching conclusion is that, no charges will be prosecuted for the overarching purpose is because there is the legal standard can't be met in Special Counsel Hur's opinion, right? So this entire study here, this investigation narrows down to that. So the narrative beyond that regarding Biden's competence or infirmness, et cetera, and sort of the media scrum and the blitz regarding, his ability to continue on as president, da 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 da. Norm, I think that it's actually fairly lacking in the broader context of this report, which means that maybe you are correct, right? Maybe what is happening in the media is some sort of setup, and it's a reflection or some sort of tacit admission that the Democrat Party is scrambling to figure out how in the hell they are going to win the 2024 presidential election.
Well, I think here's how they do it. You make it an anybody but Trump campaign. You put posters of Joe Biden standing there up and say, he's not Trump. He's not Trump. He's not a white supremacist. Save the republic. And then you kind of do damage control with Biden along the way. He gets elected, whoever the vice president is. If it's Kamala, then fine. Then you do the 25th Amendment argument that he is incapable of fulfilling the duties of office. And we're beginning to be habituated to that notion because we now have a special prosecutor openly speculating that his memory is too poor to effectively prosecute him, and that it would be unfair to prosecute him and unseemly to do so. If his memory is too poor to be prosecuted, if his memory is too poor to be held accountable for giving unreliable statements to federal prosecutors, if his memory is too poor to be trusted with giving accounts for his conduct, then should he have his finger on the trigger, the nuclear trigger? Should he be conducting the nation's foreign affairs? Should he be the chief executive officer? And the answer is obviously not. Then who should? So under the 25th Amendment, if the vice president and a majority of the cabinet declares that the president is incapable of fulfilling his duties in office, this throws then into the Congress a series of procedural moves that result in a temporary replacement of the president with an acting president, and then a strict timeline which would amount to a nationally televised competency hearing as to President Biden. And then either a congressional declaration that he is fit to do the job or he's not. What a national embarrassment that would be. I mean, at the same time that we've got Vladimir Putin being interviewed and displayed on national television via Tucker Carlson, showing a command of Russian history and a grasp of world affairs and a seemingly relentless effort to advance his country's interest and educate the populace of his adversaries out from under the leadership of their leaders. We've got Joe Biden and a debate about his competency. It's like, holy cow, what strange new world are we living in?
Well, man, this sort of leads us into a brief preview, because your homework this weekend was supposed to be that you were going to watch the Tucker Carlson interview.
I'm going to do that. I've got time.
2 hours,
my wife is
2 hours
my
long.
wife is out of town, and I've got nothing to do but screw around with the dog and and read books. So I will. Hey, Mike, can I cut you off for a sec? I
Sure.
just want to address. I do it all. You're saying, can you cut me off for a sec? You cut me off for a half an hour every morning. I mean, what's up with that? Can't you shut up, you geriatric Nickwood?
I don't know. Can you do it?
No. Freedom lover. Is that a real defense, Norm? I can't remember. So you can't charge me. No, it's not. So there's a difference between insanity and competency. A competency to stand trial means that you're aware of the nature of the proceedings against you and you can assist in your own defense. So it's possible that you could well have engaged in criminal conduct while sane and competent, but have become incompetent over time, such that it violates due process to prosecute you. Her has not quite come to that conclusion, but that's the direction in which this argument tends. And it raises an open question about whether we're openly running for president a man who's incompetent. I mean, it just does. And so that's the question. I'm sorry, Mike. I just saw
But
Freedom
that's the joke. That's the joke. That is the joke, is that, 80 million of us voted for this guy. Allegedly. But 80 million of us, in full view of the same sort of stammering, stumbling, infirmities, weird balance issues, lack of campaigning, 80 million people turn out in record numbers, voted for this guy. 80 million of us. Can you believe we were that dumb? 80 million.
Because it's an anyone but Trump thing. People are afraid of the world that we've created, and they don't know where to turn, which is what I think makes the Putin interview must viewing. I'll repeat what we said yesterday. This was one of the most audacious moves in contemporary politics, perhaps the most audacious move of the 21st century thus far. And I realize we're only 24 years into it, but Biden decided to appeal to the populace of one of his primary adversaries because he believes he has answers that that our leaders don't. And you know what? He just might be right.
Pat Clifton, the other angry dog. Here's his theory. Somebody will offer Kamala a lot of cash to resign. Biden will appoint Newsom. No votes from us. I think the whole there is that, what incentive does Kamala have to step out?
Oh, she's got none. She needs to fight for it. You can't. Kamala will engage in the Fannie Willis defense if anybody tries to replace her. You can't call me a dribbling idiot nitwit who giggles inappropriately, and because you're only doing this because I'm black, and therefore she'll ride a wave of entitlement, most likely into a second Biden-Harris term, and she'll be a dribbling bowl of oatmeal away from the White House under the 25th Amendment.
It does provide a brief opportunity to actually look at the DNC and the Democrat Party as something other than just this resolute, monolith that it has been heretofore, right? Obviously, the Biden administration and his team are fighting tooth and nail to keep him in there. You have to imagine the internal war being fought in the White House right now between those political animals of Kamala Harris, her team, her aspirations, her political ambitions, and those who are concerned now that the rest of the world sees Biden as incapable and incompetent, right? That the curtain has been fully pulled back. But he is a legitimate president, right? By all measures, right? By all discernible measures, at least in the public discourse. And I'm not talking about in terms of whether we believe the election was fraudulent or otherwise. I'm just saying he's a legitimate president. He was voted in. He was sworn in. Why do I have to move aside? Do something. Do something. Do it. And that's
there's the 25th Amendment.
So are we going to see it? I don't know.
I think if he's reelected, there's no question we'll see it. I doubt he can. He can't serve another 4 years. Hey, an interesting piece of chatter. I don't know if we have anybody that listens in who's involved in military intelligence, but we'd like to hear from you if you do. I was made privy to some discussions from some naval intelligence officers yesterday who suggested that the tidal conditions, in other words, the atmospheric conditions, waves, weather, tides, and whatnot, favor China in November for an invasion of Taiwan, and that just coincidentally would come at a time of our national elections. I'm told that there are naval intelligence officers working round the clock in anticipation of some move against Taiwan from China in November. I don't know if that's just morning conspiracy theory at the delicatessen. If anybody's got any information on that, I'm not seeing anything about it elsewhere. I'd like to know. But I raise that because, we want a steady hand at the helm as we move into a perilous world. And Joe Biden's anything but a steady hand.
Well, and, I guess we'll end by just acknowledging I listened and watched the entire interview between Tucker Carlson and Vladimir Putin. And I think you're right, Norm. It's very clear right now that the rest of the world is looking at the United States and with the same level of sort of
Who are those people? What is going on over there?
Same level of sobriety, right? There's a clear fracture between the citizenry and the moral authority that that our governing politicians used to have, and what's going on now. And what Vladimir does is tell Tucker that effectively it's never mattered who the president of the United States was. The CIA is in control, and that is who makes decisions from a geopolitical perspective. I'll let you get into the interview so that you and I can talk about, what we saw and heard. But I do think that on Monday or Tuesday, we'll let's get in the weeds with that one. Because
when you talk about the CIA being in control, I want to be a book nerd here. Read Norman Mailer's Harlot's Ghost, and you're saying all 1,100 pages of it or thereabouts. Yeah, do. It is an amazing read. It's about the CIA. It's about the era of the assassination of John F. Kennedy, and it's about the institutional incentives that people had to seize control and maintain power, and it's about whether the CIA actually had a role in the assassination of John F. Kennedy because he was deemed to be insufficiently opposed to our mortal enemy, the communists. He proposed a world in which we could all agree. If that's, and it's fiction, obviously, but, you read histories of the era, and, there's an interesting new biography of Alan Dulles. There's a new biography of Herbert Hoover or J. Edgar Hoover, excuse me. And you get the impression that for the political elites of the 50s and 60s, the global conflict between capitalism and democracy was an existential conflict, and they were willing to double down and do anything to preserve our way of life, including the assassination of a president. Similar high stakes ideological contexts are underway now. We may not have an easy adversary in the form of communism, but we nonetheless have a fraught politics where people claim that somehow our way of life is at stake with every decision. How much would people do to protect their way of lives? Would they kill? And I think the answer historically has been yes. So let's see how 2024 unfolds and where the bodies lie in the course of a year that is likely to be tumultuous.
Norm, great stream. Rumble, you guys are vibey today. We got Poot Poot as the nickname for Putin in the chat. Poot Poot.
Hi, my name is Vladimir.
And Jackson Barrett makes a prediction that the signing on to the World Health Organization's treaty in May will be Biden's last act. So we'll see if he lasts until then.
So Maury raises a question. The first AI presidency on my reading list for the weekend is a book called 2034. Wired did an excerpt from the book, and it suggested, Maury, that there's a part of it, and this is an account of the Third World War. Wired, Maury, I think the excerpt claims that in the book there's a portrayal of a dead president, but nobody knew because the current administration was so able to manipulate our perception of reality that they were able to disguise his death from us in plain view. So maybe it is time for an AI president.
Well, I think Maury is saying that Biden is the first AI president. Maybe I don't want to misquote you, Maury. You can correct me, but I've seen a ton of chatter online over the past year or so about that. So we'll see. I mean, all of the press conferences from some sort of movie set looking stuff, right? Not from the Oval Office, not from the White House. Anyway, we are here every weekday morning at 8 a.m. Eastern time on X at LawPod Daily, YouTube at LawPod Daily, and on Rumble at Law and Legitimacy. Find us at lawpoddaily.com. Subscribe to the newsletter. Make sure you're subscribed on one of those other platforms. And really, all I care about at this point is that as we continue to get our ducks in a row and draft people into the cause of giving you better content and a more organized and disciplined approach and elevating the production value of what we're doing, is that you guys tell someone else about the show. We appreciate you being here every day. We're not looking over you, but we need to continue on the path of evolving and maturing. And so that starts with you. Thank you for being here.
I'm almost 70 years old. I'm at the final destination. You may get better. I'm just like Joe Biden.
We still present you to a jury, though. Okay, you know what I mean? Maury says, "Go Niners." Any Super Bowl predictions, Norm?
Well, no, but I'm sort of a Patrick Mahomes guy. I like audacious people who are over the top and say, "What you going to do about it?" Since that's how I've
I'm
lived my life.
Patrick Mahomes.
So I'm voting for the Chiefs. Maury, you can say go Niners. It'll be a great game. Can't wait to see it. Can't wait to see you all next week here on Law and Legitimacy. Thanks for tuning in.
Yeah, betting on the Chiefs, pulling for the Niners. See you guys on Monday.